clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
We're ready to hear argument in PD number 1000-20, Santhy, Inthalangsy versus the state of Texas. You may proceed.
Thank you, Your Honor. My name is Melissa Stryker. May it please the court. I'm here on behalf of the state of Texas representing, or I'm here on behalf of the Harris County District Attorney's Office representing the state of Texas in this case. Aside from the fact that my first ground for review is numerically first, I'd like to begin my argument addressing that issue because the resolution of my first ground for review will control the outcome of my second and third grounds for review. So with regard to the first ground for review then, I'd like to, as this court's aware, the 14th Court of Appeals found that the trial court erred in admitting the state's extraneous offense evidence concerning Cassie's murder because the appellate court found that the state did not sufficiently prove that appellant was culpable for that murder as either a principal or a party. In doing so, though, the appellate court ignored the large quantum of circumstantial evidence that's in the record that establishes that appellant is culpable for that offense. The circumstantial evidence in that case includes factors such as there were 2 kidnappings in this case that occurred within days of each other. Both of these kidnappings involved either a direct application of deadly force or a threat of deadly force. And we know that because Cassie sent numerous text messages with regard to the first kidnapping expressing that she was afraid that appellant and his group would kill her over this errant drug deal that Cassie was involved in. We know that aside from Cassie's expressions of fear in her text messages, Cassie displayed fear during the first and second kidnappings, particularly given Monk's testimony that when appellant and his co-defendant escorted Cassie out of Frank's house, Cassie appeared distraught and looked like she was fixing to cry. We know that appellant had both the motive and the opportunity to kill Cassie. And notably, Cassie was last seen in appellant's, or last seen alive in the presence of appellant's co-defendant.
Ms. Stryker, were there 2 separate indictments out of this crime or just one?
There was just the one, Your Honor. There was the capital murder, which alleged an intentional killing of Jimmy in the course of an aggravated kidnapping of Cassie.
So there hasn't been an indictment due to her death, correct?
Not that I'm aware of, Your Honor.
Okay. All right.
Counsel, what's the rationale for letting the jury know that Cassie died?
Well, the evidence of Cassie's murder was pivotal to the state's case to establish 2 elements of the aggravated kidnapping. It established or helped establish that appellant restrained Cassie without her consent. It also helped establish the element of aggravated kidnapping that appellant had the specific intent to prevent Cassie's liberation through the use or threat of use of deadly force. Now, with regard to the first part of that, the first element, restraint without her consent, well, both of those elements really, one of the primary defenses at trial was that this wasn't a kidnapping, that Cassie voluntarily went with appellant and his co-defendant when they left Frank's house. So the fact that Cassie, in a very short timeline after Jimmy's murder, is killed in a very violent way, and in a way that's very similar to the way in which Jimmy was killed, tends to show, one, that she didn't voluntarily go with appellant and his co-defendant when they left Frank's house, and that appellant and his co-defendant not only threatened to use deadly force against Cassie, but they actually did use deadly force against Cassie. This court in Swearingen talked about how in a murder situation like this, where there's a murder and aggravated kidnapping, that the victim's wounds that are inflicted during the victim's death can inform the elements of aggravated kidnapping and can help substantiate that an aggravated kidnapping did in fact occur because it shows that deadly force was applied against the victim. And that's the case here. So the rationale for the admission of this evidence is that it helps substantiate the primary offense that the state had to prove here. In addition, the evidence of Cassie's murder was same transaction contextual evidence that helped the jury understand the full context of what occurred here. So appellant argues in his brief that these crimes are actually indivisible and that it was possible to tell the story of the capital murder aggravated kidnapping without getting into Cassie's death. That argument is flawed, though, because as I've mentioned, the state needed the evidence of Cassie's murder to substantiate both of those elements of aggravated kidnapping. So without those two elements, particularly the specific intent to prevent Cassie's liberation through the use or threat of use of deadly force, there was very little evidence of that aside from Cassie's death. So you have Cassie's death as the second bookend of this transaction. So these crimes are inextricably linked together, and it was not possible to tell the story of one without the other. Getting to the court's assessment of the evidence here, so skipping around to my third ground for review, the court automatically found that the admission of the extraneous offense evidence here automatically violated Rule 403 without engaging in any sort of thorough assessment of the probative value versus the other factors in the 403 test. Now, you arrive at that conclusion if you're the Court of Appeals because they found that there was no probative value to the extraneous offense evidence. But assessing the case in that situation looks at it from the wrong framework. And if this court agrees with the trial court that a rational jury could conclude beyond a reasonable doubt from all of the cumulative force of all of the circumstantial evidence, as well as the reasonable deductions therefrom, then the first two elements of the Rule 403 balancing test skew very heavily in the state's favor. So you have a high probative value of this evidence for the reasons that I've discussed, being same transaction contextual evidence and its use to prove two elements of the aggravated kidnapping. And then you balance that against the other factors. And namely, there was a very low danger of—
Counsel, but isn't that also dependent upon whether or not there's sufficient evidence to show that the appellant caused her death beyond a reasonable doubt? Like if there's not sufficient, then it's not very probative of anything.
Correct. And that's why I mentioned at the beginning of my argument, and I mentioned in my brief, that this court's resolution of my second and third grounds for review do depend upon this court agreeing with the trial court that the state did sufficiently prove that appellant was responsible for Cassie's murder as either a principal or a party actor. So with that assumption—
I'm sorry to interrupt you. Forgive me. I thought you were going to break there, but my question is the identity of the shooter evidence, is it any more compelling for one victim versus the other? I mean, is the identity, because I think there is the identity evidence was not exactly eyewitness. Am I wrong about that?
No, Judge, there was no eyewitness to Cassie's murder.
Okay, so was there, in distinction, was there an eyewitness to the other person's murder, the victim in this case?
Only Cassie. Well, obviously, and the shooters who were present.
Right. So my point is I'm wondering whether the identity evidence gets better with one victim versus the other victim.
Well, in terms of gets better, do you mean that there's a stronger case for the identity of the shooter of Jimmy versus the shooter of Cassie? Exactly.
There's two people, there's at least two people on the bad guy side here, right? And so we're not, the court admits, I think, that there are some questions as to who exactly pulled the trigger, right? So what I'm wondering is, does the evidence get better on that question in light of the fact that there's now evidence of Cassie being murdered as well?
Well, I'm not sure if I would call the evidence better. I do think that on the one hand, it doesn't particularly matter which of the defendants pulled the trigger in either instance. So appellant could be culpable for Jimmy's murder as a party or a principal actor. He could also be culpable for Cassie's murder as either a party or a principal actor. And there is evidence in this case that there were two shooters. I'm not sure if that would go to your question at all, but there were two different caliber of weapons used to kill both Jimmy and Cassie. There was a 40 caliber weapon that was used to kill Jimmy. There was a 38 caliber or 9mm weapon that was used to kill Cassie. So when
I'm glad you pointed that out. I'm not sure I would have noticed that myself without a deeper study of the record, but so that's important. And I wanted to, because that brings me back to what I keep circling around myself, is this, that the Court of Appeals suggested, the majority opinion, that there really wasn't any evidence tying appellant to Cassie's murder. And so, I mean, I frankly, I was astounded when I read that in the Court of Appeals opinion, but I'm wondering what it might be that might be causing the Court of Appeals to draw that conclusion.
Well, frankly, Your Honor, I think it's the lack of direct evidence. I believe that the lower appellate court, at least the majority, of course, became fixated on the lack of an eyewitness. They really emphasized what the state didn't prove, in terms of the state didn't provide DNA evidence, for example. They didn't provide an eyewitness. They didn't provide other direct evidence that basically put a gun in appellant's hand and showed that appellant pulled the trigger for Cassie's murder. As I've said, I think in doing so, the court basically disregarded a large amount of circumstantial evidence that gets to the same point. And that, of course, contradicts this court's longstanding jurisprudence that circumstantial evidence is as probative as direct evidence in establishing guilt. And it also ignores a lot of jurisprudence from this court, where this court has affirmed murder convictions based on circumstantial evidence, and even less circumstantial evidence than we have in this instance. I cited in my brief the Nisbet case, where you have a situation where the victim is missing. There's never a body found, there's never a weapon found, but you have evidence such as a violent relationship between the victim and the defendant, who were husband and wife. You have an episode of recent violence during an argument that happened in the days before the victim's disappearance. You have the fact that the defendant had motive and opportunity. And based on essentially those facts, this court didn't have any hesitation to affirm the defendant's murder conviction in that instance. I think here, there's substantially more circumstantial evidence that ties appellant to Cassie's murder. And by disregarding all of that evidence and really faulting the state for not providing what the court found was necessary, which is namely direct evidence, the 14th Court of Appeals erred in assessing the sufficiency in this context. If there aren't any other questions, I'll go ahead and yield the rest of my time to allow appellant's counsel to begin her argument.
Thank you, counsel.
Thank you.
Good morning, Your Honors. My name is Inger Chandler, and I represent the appellant in this case. May it please the court. This is an interesting case for a number of reasons. First of all, the cast of characters extends beyond the three that we hear the most about in the trial. I think it's important to note at the beginning of this case that our victims in this case, while their deaths were certainly tragic, it's very clear from the record that Cassie was involved in some very dangerous things. Certainly not saying that she deserved to die, but we don't know the full story of Cassie and all of the various things that she might have been involved in. What we know is that she did get crossways with the main three co-defendants, the three co-defendants that were charged in this offense. And that would be Linda, Amelin, and my client, Santhy. But all of the evidence points to the fact that Linda is the leader of this group. And the reason why I point that out is that she seems to be the leader of this Asian drug cartel, for lack of a better word, and that any of the doing that happens tends to happen in her direction.
Counsel, is your position that the multiple different actors in this situation undermine the idea that the circumstantial evidence points to appellant as having been the person who killed Cassie or was a party to it?
And Judge, that's exactly my point. I think the concern here is that we have evidence, and it was substantial evidence at this trial. We had a medical examiner, we had photographs, we had Cassie's father, we had investigators testifying about her death, and there is absolutely zero evidence that links her death to my client. And I'll address the circumstantial evidence in just a moment, but I think that this story was able to be told. And again, Judge Richardson, as to your question about the indictments, the original indictment and the only indictment in this case alleges the death of Jimmy in the course of kidnapping Cassie. That entire story can be told without ever talking about Cassie's ultimate death. And what it does when you introduce that type of really compelling and really prejudicial evidence is all it does is confuse the jury, and especially
But wouldn't the jury be wondering what the heck happened to her and why isn't she testifying? And that would just be this big, huge question mark and totally distort the case, wouldn't it? I mean, it seems like it would to me.
And Judge Keel, perhaps that would be the case, but there are certainly ways. I mean, we try cases without witnesses all the time. We tried domestic violence cases without cooperating complainants. There was evidence prior to kidnapping.
But there's an explanation most of the time for why they're not there. And if this jury didn't know that the woman was dead, they'd be wondering, and they would have no explanation. Where was she?
Well, and to answer that question, I think that we have to look to the state and the reason why they charged the case the way they did, the reason why they didn't file a charge for the death of Cassie. Ultimately,
Doesn't it go to the motive and intent of your client to show the initial killing and just supports that claim if that's your position, that they've just left it out? Because I mean, it would be so easy for the prosecution to argue, where's Cassie? Why didn't she testify? She could have come in and clarified this, and the state would be powerless to do anything at that stage.
I think my concern, Judge, and my concern the very first time I read this record is that there were a number of ways that the state could have made this evidence more relevant, and they didn't. There are 2 charged co-defendants that could have been flipped. There are additional people. There are multiple people that are mentioned in this record. We have individuals such as, in addition to the main 3, Linda, Santhy, and Emmeline, Lucky is somebody that we never hear from, who's involved in the robbery that becomes the basis of the dispute between Linda and Cassie. We hear names. We hear about a person named Harry that was with Linda at one point at Monk's house. That's in the record at page 69. Monk goes to Linda another time, and there's a guy there named Tehum, T-E-H-U-M. We don't know anything about him. Andrew Contreras is mentioned. There's a fellow named Joe. There are so many people within Linda's world that to attribute this death to my client without any evidence that he had anything to do with her death. In fact, the last thing that we hear, and we hear this from Monk, is that when he goes over to Linda's house, so Monk is sitting outside of Frank's house. He hears what he believes is the door, the door slamming shut. Of course, we ultimately find out that was a gunshot that killed Jimmy. He then sees Cassie leaving with my client and Emmeline. He goes to a Texaco station, gambles for about 45 minutes, and then drives to Linda's house. And when he gets there, my client and Linda are there, and he doesn't see Cassie. So but doesn't that sort of cut against the whole idea that it could be Lucky or it could be Harry or these other people? I mean, the last 2 people that she's seen with are your client and then she's missing. And so it's like, why wouldn't we look at that evidence and see whether or not you could say that evidence established beyond a reasonable doubt that they're the 2 people responsible for Kathy's death? Because and maybe this is a lofty Pollyannic view, but what if they weren't involved? What if they didn't kill her and we're admitting evidence that my client is somehow involved in this murder when there was ample evidence prior to the instant offense that helped the state and enabled the state to establish a kidnapping? And that was supported by the 14th Court of Appeals. They very clearly and made sure they didn't answer all of my points of error, but they did say that there was sufficient evidence absent this extraneous murder to support the capital murder conviction. The concern.
Was there a jury charge that on an extraneous offense, the state had to prove it beyond a reasonable doubt?
There was, Your Honor.
Okay, so doesn't that cover the problem of what if they didn't do it? The jury got to decide.
They did. I think that the concern that we all have is that there are bells that can't be unrung when you're in trial. And whether or not, I understand that we trust the jury to follow the law and to to take the court's instructions seriously. But when you're talking about evidence of a murder, and the state has said that there were so many similarities between the death of Jimmy and the death of Cassie, but that's really not true. Jimmy was shot one time in the face, absolutely horribly. Cassie was shot to pieces. She had multiple gunshot wounds.
In the face too, right?
He had a single gunshot wound to the face. And Judge Yeary, to kind of hop around and address your concerns about the, how do we know the identity of the shooter of Jimmy, and is that important? At the trial, the investigating officer, the homicide investigator, he was elicited from him that he believed that Amelin was the shooter of Jimmy. Now, he didn't eyeball witness that. The only people who eyeball witnessed who shot Jimmy were Cassie, my client, and Amelin. But that was based on his training and his experience and his full investigation of this case. Homicide investigators are often limited to the things they can testify to at trial because most of what they do and most of what they learn is hearsay, but it was his opinion that Amelin was the shooter. The fact that there are two different guns doesn't necessarily mean there are two different shooters.
Doesn't that make Cassie an eyewitness to this murder though? I mean, that gives them a pretty strong motive to not let Cassie live.
Sure. It also means that there was a gun present at the time that they escorted her out of this house, which is also an aggravating circumstance for her kidnapping. The fact that she was uncomfortable, the fact that she looked like she was about to cry, the fact that we now know that there was a gun present right before she was escorted out of the house, there was ample evidence to support an aggravated kidnapping in the court at the time that Jimmy was killed.
Is there a parties charge in this case?
I'm sorry,
Is there a parties charge in this case?
Yes, Your Honor. The parties, conspiracy, the whole bag of tricks that we usually see in cases like this. It was all in the jury charge. And the timeline of this case is really important, Your Honors. This is a case that literally happens within a span of a couple of days, although clearly there's a relationship between Cassie and Linda's group prior to. But on May the 2nd of 2015, Cassie is texting her landlord, Ryan Overton, and saying, I can't pay you the rent because I'm being held hostage. She tells him about the $70,000 drug robbery that occurred that has her in hot water, talks to him about the fact that she's trying to liquidate her dad's boat, to get her out of the situation. Monk sees Cassie at this time when she's at Linda's house, or Linda's residence, I should say. He sees her there and says that she's being held there. 2 days later, Cassie returns back to the Overton residence where she's renting an apartment. She stays 2 nights there with Jimmy, and then Overton kicks her out. He kicks them out, evicts them for non-payment of rent. But that very day, there are individuals, there are 3 Asian males that go to Overton's house looking for Cassie and Jimmy. One is armed based on the testimony. And the reason why I emphasize 3 Asian males is that our core group that we always talk about is a female and 2 males. So we have a third person involved whose identity we don't necessarily know. Then at 10:30 that night, we have 2 Asian males and a female who ultimately get identified as Linda, my client, and Amelin, who jumped the fence at Jimmy's parents' house looking for Jimmy and Cassie. But there's another individual that's on the other side of the fence. So we have kind of a mystery additional player in all of these facts. There's certainly case law out there in jurisprudence that I respect about how low the threshold is for evidence. But I think what we have to be careful about is how low are we really willing to go? These extraneous offenses have to be proven beyond a reasonable doubt. And while certainly circumstantial evidence can support a conviction, we are talking about a body that's discovered approximately 24 hours after this offense occurred, about 60 miles across town, in the Ship Channel area of Houston, Channelview, for those of you who are familiar. There is absolutely no forensic evidence that links anybody to this case or that links any of these charged defendants in this murder. We don't have anything. We don't have surveillance. We don't have statements from co-defendants. We don't have anything that truly links these charged co-defendants, and in particular my client, to this murder. And the reason why that's important is that when we look through the case law involving extraneous offenses, you at least see some evidence that the defendant's involved in that extraneous. When we talk about aggravated robberies, right, and we admit several of them for the purpose of identity, for example, that defendant has been identified either through face, MO, in order for those extraneouses to be admitted.
Let me ask you this, Ms. Chandler, if this had been tried separately, if they had gone to trial for Cassie's murder, are you saying that no rational jury could have found him guilty based on this evidence? There's just no way a jury could have evaluated this evidence and come to this conclusion.
You know, Judge, I'm not willing to go there. I'm not willing to say that. What I am willing to say is that that's not what the state did. My concern is that, well, and let me back up.
Is that the standard though? I mean, if the jury had to find it beyond reasonable doubt, if that's what they were charged with, is that the standard that we're looking at?
Yes, and let me back up, not to backtrack, but to say that if the only evidence introduced was the finding of Cassie's body in Channelview, with no forensics, with no eyewitnesses, with no evidence, which is essentially what we had here, I don't know that a jury could find beyond a reasonable doubt. I would imagine, though, in that circumstance, that the state would argue that some of the prior activities would be same transaction contextual evidence. I think the problem here is the order of the events and the way the state chose to charge this case.
But we do know that they were together, right? Within 24 hours of her discovery deceased, right? And we also know that both victims were killed, albeit, somewhat differently, but they both were shot in the face, which, I mean, I don't know that that's necessarily the most common way of committing a homicide, but it's a firearm with a bullet in the face. They were both together with the same group of people within 24 hours. There's something there, isn't there?
Well, and I'll tell you this, Judge, and I appreciate you saying that. The 14th Court of Appeals actually says that it's easy to imagine that these two events are linked. But is that how far we're willing to go? Imagining that they're linked doesn't mean that they're linked. And you asked before about the guns. I think it's important to note that the fact that you have two different caliber guns doesn't necessarily mean you have two different caliber shooters. It doesn't necessarily mean that just because my client and Amelin are the two that were present during Jimmy's murder means that my client and Amelin are the shooters, period.
I mean, they kidnapped her, right?
Well,
they took her at gunpoint and they're the last people to see her alive. That's not too much of a stretch.
And she can implicate them in a murder.
She can implicate them in a murder. And they had taken her before. All of that leads to what the state set out to prove, which is that Jimmy was killed in the course of kidnapping Cassie. The state mentioned the Nisbet case, but a fact that she left out of that case when we talk about the admissibility of, or the circumstantial evidence to prove that case, is that there was also a bloody handprint in that case that contained the victim's blood and the defendant's fingerprint. The state in their brief mentioned the Ingerson case. In that case, the court found that the defendant had motive, opportunity, was the last person to see the victim alive, but he also owned the type of gun and ammo that was used to kill the complainant. He also acted suspiciously after her murder. There's at least something about that defendant that links or tends to link him to that offense. The state cites the Brimage case for same transaction contextual evidence. Again, in that case, the defendant gave a written confession of both of kidnapping and killing the victim. Swearingen, I know it's a case we're all very familiar with, but in the Swearingen case, it's also this, and it's something I'd like to point out about Brimage and Swearingen is that you have the same complainant. It's the same complainant that is kidnapped or robbed or, for capital murder, it's the same victim that is kidnapped, that is killed. Here, and I think what makes this case unique is that this case was charged as the kidnapping of the killing of Jimmy, the intentional killing of Jimmy in the course of kidnapping Cassie. The Rogers case that cites Mays, I think, the quote from Mays is so critical here, and when we're talking about same transaction contextual evidence, and that is, that only if the facts and circumstances of the instant offense would make little or no sense without bringing in the same transaction contextual evidence should it be admitted. This case makes absolute sense, and as the 14th Court of Appeals found, there's sufficient evidence to prove that.
But the evidence here is not only admissible because it is same transaction contextual evidence, right? I mean, under 404B, there are a lot of reasons why evidence of another crime can be admissible. There's only one reason why it shouldn't be admissible, right? So here we got, there are a lot of reasons it seems to me that this evidence should be admissible if they, if it's actually relevant to them. And that's what the Court of Appeals says, well, it's not relevant to those things. And I frankly, I'll tell you, I'm having a hard time with that. So.
Well, and I think what it comes down to, Your Honor, and I certainly respect your position, and I anticipated your position there, but what I don't see in this case is where the death of Cassie is inextricably interwoven in the murder of Jimmy and her ultimate kidnapping. And the concern and the danger is that when you introduce such prejudicial evidence as an extraneous murder with absolutely no ties other than temporal proximity, then what the risk you're taking in a conviction that is based on something that shouldn't have been introduced in the first place is high. And that's not what we want to do. That's not the business that we're in. We want to make sure that appellants, defendants have fair trials, that they are convicted based on relevant and relevant and probative evidence. And in this case, the state went too far. They didn't need this extraneous murder. They didn't need it. And the fact that they thought they need it might speak to what they perceived as weaknesses in their charged offense, but that was the horse that they chose to ride. And they could have pled this case a number of different ways. They could. So
when you suggest that it's the state's need that is the sort of compelling factor in your view, I wonder whether you're focusing on more of a 403 analysis or a 404B analysis. I mean, it sounds to me like you're focusing on a 403 analysis, which, I mean, frankly, I can see that argument better, right? I mean, your argument becomes much more compelling under those circumstances than under 404B. But the Court of Appeals focus seems to be on 404B. So I don't know if you can elaborate on that. Your time is running short. I don't mean to take it all up either.
I see that, Your Honor. Yeah, I think the concern is that when we continue to allow the introduction of evidence that is not inextricably intertwined, right? Is not really substantiated by any real, and not just direct evidence, but proof, something more than mere speculation. We just run the risk of unfair results. And I believe that that's what happened in this case. This case could be retried without this extraneous murder coming in. We could end up with the exact same result. But at least we wouldn't worry about whether or not it was that extraneous evidence that resulted in the conviction and not the distinct murder and kidnapping of Cassie that was very easily provable without the extraneous evidence.
Thank you, counsel.
Thank you, Your Honors.
Ms. Stryker?
Yes, Your Honor.
Let me ask you this question. If evidence is, if there's evidence that is not inextricably intertwined with the evidence of a case on trial, but there's evidence of this crime that is probative on another important issue, do the rules require that the evidence be excluded because of the fact that it's not inextricably intertwined with the evidence of the crime on trial?
No, Your Honor. The rules of evidence allow for, as you mentioned in your discussion with opposing counsel, the rules of evidence allow for the admission of evidence under a lot of circumstances, and particularly with regard to extraneous offenses. Rule of evidence 404B enumerates a list of permissible uses for that evidence, such as to prove motive, intent, opportunity, the absence of mistake. I believe same transaction contextual evidence would fall as another unenumerated 404B purpose for evidence. But in this instance, as consistent with the point that you made with opposing counsel, even if this court doesn't agree that this was same transaction contextual evidence, the evidence was admissible under 404B to prove those two elements of aggravated kidnapping that I mentioned, namely restraint without Cassie's consent and the specific intent to prevent Cassie's liberation. So the resolution of this case doesn't turn on whether it was same transaction contextual evidence. There are other admissible purposes for that evidence. And discussing same transactions contextual evidence, I do want to draw this court's attention to the Camacho case that I cite in my brief. The reason I think Camacho is important here is that in that case, there was a capital murder charged with an intentional killing in the course of a burglary. Now, through that offense, a woman and a child were kidnapped from the home that was burglarized, were taken to Oklahoma, and were subsequently murdered some days later. So you have a much larger geographical location than you have here, and you have a much larger span of time than you have here. And in Camacho, this court still found, I'm sorry, Your Honor.
But you only have one person, right? You only have one suspect, not multiple different people. No Lucky, no Harry, no, you just have this one guy.
Well, you have Camacho and his entire gang. So it was a whole group of people that committed. And so Camacho, of course, was the individual on trial in that specific instance. But the facts of Camacho mention that it was Camacho with several other people. And just like in this case, where opposing counsel says that, there was a whole cast of characters that we don't know about. Again, sorry, Your Honor. I'm sorry, I thought you had a question. That's speculative, and I think takes this court outside of the record that we have here. The record that we have here provides abundant circumstantial evidence that establishes appellant's guilt as either a principal or a party. I think appellant's counsel and the 14th Court of Appeals, again, as I mentioned before, really strongly emphasized what the state did not prove, witnesses the state did not bring forward, and ignores what the state did prove and the witnesses that we did provide. And when you look at that evidence in its totality, as well as all of the reasonable deductions that you can draw from that evidence, the trial court appropriately found that a jury could find beyond a reasonable doubt that appellant was culpable for this. So when the evidence in the record is viewed in the proper framework here, the state met its burden to show that appellant is culpable for that. Therefore, the trial court met the threshold of Rule 104 and this court's guidance in Harrell and appropriately admitted that evidence. If there aren't any further questions, then I'll simply pray that this court reverse the opinion of the 14th Court of Appeals on the basis that we've discussed.
Thank you, counsel.
Thank you.
The case is submitted and the court stands in recess. The clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.